One of the things we want to do in this video is to help you guys prepare your case if you happen to be in an unfortunate situation where you or someone you care about is accused of domestic violence.
7 bad things that happen when the police come to your house for domestic violence. Number 1, somebody's getting arrested.
Number 2, you may not be allowed to come back home even if the person who called the police really would like to have you back.
Number 3, there's going to be an emergency protective order issued where you cannot contact your kids or your wife.
Number 4, even if your spouse decides not to cooperate with the police, you can still be prosecuted and she may be forced to testify under some circumstances.
Number 5, any firearms you have in your possession are immediately going to have to be turned in to the police department or to a licensed gun dealer. Number 6, you could lose your job, your professional license, your livelihood.
Number 7, they will force you to attend mandatory counseling for 52 weeks or 104 hours. Even if you are no longer together with the same person you're accused of having committed domestic violence on.
Now that we heard all the bad things that could happen if the police come to your house for domestic violence, I want to cover some of the things that you should do to help yourself get out of this situation. Number 1, what should somebody do at the scene?
What happens at the scene is incredibly important because this is your first contact with the police. So please make sure, number 1, don't talk to the police officers and certainly do not confess to any crimes. Number 2, make sure not to talk to the police even if you're not at fault. Number 3, please make sure if you suffered any injuries during the incident that all of your injuries are documented. Having fresh photographic evidence that you may have been a victim of some kind of domestic violence will be incredibly important for your lawyer down the road in building your defense.
Now, when you go to jail, what are some of the things that we should be worried about, do's and don'ts once you get to the jail?
When you get to jail, what happens next is extremely important. By law, the government has to give you 3 phone calls to make to your bail bondsman, to your loved ones, and to a lawyer. However, the phone call to the person who you love, who may have been the alleged victim in this case, is going to be the most problematic for you. Number 1, you're calling a person with whom you were in a relationship for a long time after a really bad fight. You're liable to say some things to a person who's emotional or upset that might not make either one of you look good. And it might even show that you are guilty. If you apologize, if you say that you are sorry for something that happened, the police are likely going to take it and use it as evidence of a crime. They're going to treat it the same way as if you had confessed. Number 2, when you get to the jail after you've been arrested for a crime of domestic violence, the police are likely going to serve you with an emergency protective order. If you call someone after you've been served with an emergency protective order, you're going to be committing a new crime, even if you were completely innocent of the domestic violence offense in the first place. Number 3, any phone call you make while you're in jail is 100% recorded, and you have no right to privacy. That means that if you say some things on this recorded phone call that you might regret later, you will nonetheless see them play out against you in a criminal court. And lastly, please make sure to never, ever, ever ask the person who is a witness or a victim in a criminal case to withdraw charges against you, not cooperate with the police, or say anything that's going to make them less likely to be a witness. That's because if you do those things, the government can charge you with an additional crime of dissuading or intimidating a witness, even if you were completely innocent of the domestic violence case to begin with.
Once you get out of jail, if you bail out or they release you, what are some of the things you should do before you go to court?
Once you get released from jail following a domestic violence arrest, the most important thing for you to do is to get yourself the best possible lawyer you can hire. That's because a lawyer who is trained in defending cases involving domestic violence is likely going to be part of a larger network of specialists, substance abuse treatment providers, mental health treatment providers, marital counselors, and will be able to help you not only fight your criminal case, but also possibly repair the damage done to the relationship by the incident involving you, if this was not a case where the allegations are false. Number 2, when you go to court, the government is likely going to ask for you to not be allowed to return home. That's because statistically, the government knows that when couples reunite following an incident involving domestic violence, the victims or alleged victims are much more likely to refuse to cooperate. So the government knows that if they can keep these couples apart, they will not only protect and preserve testimony from the alleged victim or the accuser in the future, but also keep someone safe from a person who allegedly abused them. It would be really helpful before you go to court if you enroll in marital counseling, assuming that the protective order has already expired. It would be really helpful if you addressed any underlying problem, such as mental health issue or substance abuse issue that may have contributed to the incident involving domestic violence. And most importantly, you always have to have a backup plan for what to do in case things go wrong. What happens if you go to court and the judge issues a restraining order? You do not want to be making arrangements for how to get your things, how to see your children, how to find a place to live when an emergency order is issued. You don't want to be making these arrangements on the fly. You want to give yourself sufficient time in order to find a new temporary housing, a new place where you can store your belongings. You want to make sure that you have made these arrangements in advance, because once criminal protective order issues, it will be against the law for you to have any contact with the person who made these allegations against you, who is considered to be the alleged victim in this case, directly, indirectly, or through a third party, such as a parent, a child, or a common friend.
What are some of the things that you should do to help your case move along for an outcome that's desirable?
The most important thing to do is to work with your lawyer to develop a strong theory of innocence in your case. In California domestic violence cases, we commonly see 3 or 4 possible defenses. The first defense we see is the defense of accident. The defense of accident only applies in a small group of cases where the injury was inflicted accidentally and not as a result of willful or intentional, purposeful behavior. For example, if you are arguing with your spouse and you slam the door because you're angry, but did not realize that your spouse stuck her foot or his foot inside the door and you strike him by accident, that could be a defense to a crime of domestic violence. Number 2, if the argument between you and your spouse got really bad and your spouse has gotten violent with you, if your spouse has gotten in your face, striking you, hitting you, pushing you, or preventing you from leaving, you might be legally allowed to use some force that's reasonable and proportional in order to defend yourself. Number 3, if your spouse claims that there has been an injury inflicted upon her, but you believe the injury happened because of some other incident or inflicted by someone else, that too can be a defense. And lastly, one of the most creative defenses that we sometimes use in extraordinary cases involving domestic violence is the defense of necessity. For example, if you're driving down the road and you get into an argument with your spouse is hitting and striking you and putting you in a dangerous emergency situation where you have to use force in order to avoid greater harm, the law might permit you to commit a crime of domestic violence, such as by striking your spouse or neutralizing the threat, if the greater harm can be avoided, if you did not substantially contribute to this emergency, and if you had no lesser available alternatives, such as calling the police or pulling over.
Can you give us a wrap-up of the main points that you talked about so somebody has a checklist of what to do?
So here is a short list of 7 things to do and not to do. Number 1, please don't talk to the police. 2, please make sure that all of your injuries from the incident are documented, either by showing them to a police officer, showing them to a nurse in a hospital, showing them to a staff member at jail, or taking photographs before or after visiting your lawyer after you've been released from custody. Number 3, when you are served with a protective order, please make sure to comply with the order. Please make sure that you surrender any guns that you own or have registered under your name and surrender them to a licensed federal firearms dealer. Number 4, please do not communicate with the protective party, either directly or indirectly. If you do communicate with them, especially via text message, you will be creating evidence of a new crime, even if you are completely innocent of the underlying domestic violence offense. Number 5, please never, ever, ever ask a victim or a witness of domestic violence crime to not testify against you, to not cooperate with the police, or to withdraw the charges that may have been pressed against you. The rule in California is that once a police is called for a domestic violence incident, even if the person on whose behalf the arrest is made changes his or her mind, the government can still prosecute you for a domestic violence crime, whether the victim or alleged victim wants it or not. Number 6, after you've been released from jail and before you go to court, you gotta work with your lawyer, you gotta work with your marital counselor, you gotta work with your substance abuse treatment provider or mental health treatment provider to fight like hell to stay in your home, to stay with your family. The government is going to try very hard to separate you because they think that you're a danger to their safety and they think that you're a danger to their case. Please don't let them do that. Give the judge all of the evidence that the judge may need to find that you should be allowed to have peaceful contact, to find that you should be allowed to return to the home that you pay for, that you have lived in. Don't let them take you away from people you love and keep you away from them forever. Finally, make sure you share with your lawyer any evidence of past abuse that may have happened against you. Make sure you share with your attorney and any evidence of past dishonesty or violent behavior committed by the person who is now accusing you of domestic violence. Those things can go a really long way in court in proving your innocence. We hope that you found this information helpful. If you like this video, if you have any questions or comments for us, please like, subscribe, and send us a question. Thank you very much for watching.